Welcome to another exciting episode of Unraveling Intellectual Property with Michael Stein. Today, I am so pleased to have PD Leardi of Studio Leardi in Milan. Welcome back.
Thank you, Michael.
We've already discussed things like designs, we discussed trademarks and things to consider when filing. Let's go to enforcement. Very complicated subject. Let's keep it on a high level. Um, Generally, we'll start with trademarks. We'll hit patents. Uh, and we were talking briefly before about uh, enforcement, but then you said we need to consider enforcement at an earlier stage. So why
Yes.
don't you not just elaborate, tell the audience basically what we were talking about uh, to educate them on things they should consider and when they should start considering them.
Absolutely. So thank you, Michael. So intellectual property enforcement is really the core of intellectual property. No, you are willing to have intellectual property to prevent others from doing something. No, intellectual property is not something that allows you to do something, is something that allows you to prevent others from doing. So the first thing you have to keep in mind as a business, as a manager, when you're starting building your IP portfolio is that when you're starting building it, it's really the key moment for building a portfolio of valid and enforceable IP rights, because anybody can get a registered patent, a registered trademark, but most of them cannot survive, for example, a nullity action.
What action?
A nullity action.
Nullity. Okay.
Not nullity.
Yeah.
A nullity action.
What's a nullity? Like an opposition cancellation? Oh, because
Position cancellation?
yeah, we
Sure.
don't usually use that term in the U.S.
Oh, how do you say that?
Well, it depends what it is.
Okay. So cancellation actions generally take place during examination procedures. And they can be office actions made by the examiners, or they can derive from third parties action. But once the trademark or patent has been granted, it's still open to what we call a nullity action. So it can be declared null and void if the registration does not meet the validity requirements for each and every intellectual property. And so during enforcement actions, when you are enforcing your right, the first typical defense of the alleged infringers is claiming the nullity of your intellectual property. And this is typical. This happens all the time.
Yeah,
No?
U.S. I mean, everyone says invalid or nullity, and I don't infringe. I mean, that's kind of
Exactly.
I assume
Exactly.
everywhere. Right.
Exactly. So this is the reason why when you're conceiving your IP portfolio, being extremely careful in filing and prosecuting those rights that you believe are really valid from a legal point of view is really crucial for a subsequent enforcement of those rights.
All right. So I'm a U.S. company. I'm selling my products in Europe. How do I bulletproof my intellectual property? Because you say anyone can get a registration. Okay, so I don't want just registration because I don't want to just pay money for nothing. I want something. I want to enforce. So what does a U.S. company need to do to get that enforced or avoiding nullity?
So bulletproofing your IP rights is impossible, but what you can do is you can assess as more careful as you can the validity requirements of each and every intellectual property right. For example, trademark has their own validity requirements, patent have their own. And the later you start assessing if you meet those requirements, and the worse it gets. So as soon as you start studying prior art with prior art searches to see if you meet all the requirements is what you can do to start prosecuting IP rights that can be considered valid during an infringement trial.
So, I mean, switching to patents, let's say I file via the PCT.
Yeah, sure.
So then let's say I use the European Patent Office as my
Sure.
search authority. So I'm
Yeah.
going to get, I mean,
The
a search
examination rep.
report.
Yeah. A search rep. Yes,
Okay.
exactly.
But I'm not going to, in trademarks, I'm not going to have that.
Exactly.
Okay.
Exactly. Even if the examiner might refuse your application you for nullity grounds, and but nonetheless, if the examiner does not do that, and you eventually have the application granted, the registration is still open to what we call the nullity action. That is generally put forward by the infringer during an infringement action as a counterclaim.
So let's say I've got a US application. Let's say it's registrable in the US,
Mhm.
but let's say I run into problems in Europe.
Okay.
Is there anything I can do to tweak the application, or do I just have to file
No,
something else?
no. You can, if I understand your question correctly, I am no, you cannot do that.
All right. So if you are going international, I guess basically before you make the decision on filing in the US slash Europe and wherever, you've got to go through the process of doing the search
Exactly, exactly.
in
Yeah,
advance. And
yes,
then,
absolutely.
I mean, I don't know, is there a difference in like, not to get into the details, but like where you file? I mean, are we filing in a specific country? Are we filing in a European court? Uh, I know it's a broad question, and I'm sure there's a lot of details, but can you keep it on a super high level? So,
Sure.
let's say I have a European application and I see infringement in Italy. Where am I filing?
Okay, so
And what type of court is it?
sure. Okay, so we have generally okay in the for what concerns patents, now we have the UPC courts, and which are a very useful tool that allow you to file um, patent infringement actions that cover the entire soil covered by the UPC agreement, which is incredibly effective. And we have national courts that can be used to obtain pan-European injunctions. When it comes, for example, to trademark infringement, you tend to go in the court of the alleged, I'm sorry, the alleged the alleged infringer, and then if depends on the type of right you are relying upon, you can get a national infringement, a national injunction or a pan-European injunction, depending on the title you are enforcing.
All right. I'm guessing at that point it gets pretty complicated.
Yeah, it is. It is. It is.
But this is kind of an overview
Yeah.
of
Well,
enforcement.
generally, as a general remark, no, it's what is generally you are willing to do is crucial to decide whether you want to send a cease and desist letter prior to start an infringement action or not. And generally, the difference is that you wanted to surprise the infringer with your action, or you are willing in a way to find a solution, a possible amicable solution to the problem. So that's generally number one decision to be made. Second, of course, to assess the validity of the right that you want to enforce, and if the scope of your intellectual property covers also the infringing product. These are the main things that you have to assess.
All right. Well, that's all we have time for. Do you have any parting pearls of wisdom?
Sure. Again, as I said before, just be realistic. Sometimes when you have an infringer, first thing we do is to do some intelligence on who they are, and generally our clients know them better than we do. And so deciding the litigation strategy really depends on the relationships between the two parties. For example, you already know they will never sit on a table and discuss how to stop. You just sue them right away. If there's a possibility to find an agreement, we will find a way.
All right, sounds great. Thank you, PD. Quick plug, name of your firm?
Studio Leardi, Milano, and my contact is leardi@leardi.it.
Okay, thank you so much.
Thank
Uh,
you.
Appreciate it. And to my audience, thank you for tuning in to Unraveling Intellectual Property with Michael Stein. Till next time.